and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this particular episode, I'd like to talk about another decision which Attorney General Jeff Sessions made, which essentially tries to limit, again, the power of the immigration judges in actually deciding and ruling on and running the cases themselves. We had spoken in prior videos about, basically their inability now to administratively close the case for various reasons. We had spoken about Attorney General's revocation of the case allowing domestic violence cases to be considered to be, eligible initially for as a social group for asylum, and the reasons for that. And now the Attorney General has just come out with a decision essentially saying that at the present time, immigration judges cannot continue an immigration case unless there is good cause. And that by itself is nothing new. I mean, they don't just, say, okay, fine, we'll continue. You really always had to show good cause, but it's some of the new definitions of what constitutes good cause, which is giving serious concern. The biggest one, as I read the decision, was that there's what's called collateral relief. So let's say someone's in immigration court proceedings and they have a crime, and that's why they're in proceedings. And let's say that the immigration attorney simultaneously is going back to criminal court to try to vacate or reduce the crime, so that in the end the person will either not be considered an aggravated felon, or will be admissible, or will be eligible for a waiver or adjustment or whatever it is. So now the Attorney General has said that the immigration judge, which has probably never stepped inside a criminal courtroom, now has to evaluate the criminal relief or the collateral applications outside of immigration court as to their validity and to their ability to be granted and to the probability of it being granted. Now, first of all, how on earth is an immigration judge supposed to put his or herself in the shoes of a criminal judge and switch from immigration law to criminal law and be able to make a realistic analysis of the probability of success of collateral relief? It's not doable. It's unrealistic. And to request and require that now is a part of determining whether or not good cause exists to grant a continuous is just pure silliness, because it can't happen. So in effect, what it is saying is that, the immigration judges, if they follow this, which they have to, because Attorney General Sessions essentially is their boss, they're just going to say there's no realistic chance of success and then deny the continuance. Because if they have to give a detailed analysis of why they believe there is a good chance of success, they won't be able to, since they're not a criminal judge and they're not in criminal law and they're not in criminal court, and they don't even have the criminal file in front of them. So what Attorney General has done is further limit the immigration judge's ability to rule and to run an immigration case. Essentially, step by step, what he's doing is turning the immigration courts into puppet courts. You have these in other countries, like most of the criminal courts in China are like this. They have, for example, a 99% conviction rate. If you're brought into criminal court, there's almost no need in China to have a criminal attorney, because everything gets convicted when they're standing in criminal court. There's a complete lack of due process. And that is where Attorney General Sessions is moving the immigration courts. It's number one, it's un-American, and number two, it is chipping away at the due process of the immigrants. They have certain rights given by law, including due process rights, and those due process rights need to be followed. If Attorney General wants to essentially remove all the due process rights, he's going to have to do more than just chip away like this. Because, for example, the ACLU is already fighting back on another decision that Attorney General made, which, hopefully that will prevail. But what we have to do as immigration attorneys is just fight this. It's just a matter of if the judge denies the motion to continue because they can't put themselves in the shoes of a criminal attorney. We'll just appeal it up to the BIA and Board of Immigration Appeals, and then we can appeal it up to a petition for review to the circuit courts. So while Attorney General thinks that his actions are actually going to speed up and get more people deported, the reality is it's going to slow things down and create a bigger backlog at the Board of Immigration Appeals and the circuit courts. That's the reality. So that's how it is. So if you like the video, click like, subscribe, and more on the coming videos. Thank you.